Just thank you to council for accommodating the personal situation. Thank you very much. Mr. Mathieu?
Lord, as you noticed before us, we did not file that case at that stage. We had some difficulty during the break to find it. I can appreciate this my colleague did not want to present hers, but she had made notes on it. So we found it at last, but it was quite difficult to obtain.
Which case is that?
It is the one that she referred to, that she was going to refer the witness to, my lord, which is S versus Isaacs 2007 JDR, which is a reference which I'm not very familiar with.
Is that the same case, Doctor, that you want to refer to?
My lord, that was the case that the state had wanted me to answer on.
Yes, that's what I mean. Yes, sorry, the case that Ms. Galloway, or the state wanted to have comment from this witness. There are two aspects, my lord, that I want to deal with. That there is one is we are.
It's something to do with the case.
Yes.
Well, I haven't seen the case.
No, I understand, but I'm just saying that what I would suggest is if the state is intent on putting this case or having comment on this case from this witness, I would suggest that stand over, because we would like to address you fully on that. I think this case is wholly distinguishable from this instance for various reasons. And then one other aspect that I want to deal with is the testimony. So
you want to stand down cross-examination on that case?
On that aspect.
Until everybody is ready, that's fine. What's the other point?
And the other aspect is the question that was put to her about, the statement put to her about what Lieutenant Colonel Otto testified about. I'm not in agreement with what was put.
But that you can rectify in a re-examination.
That might be so, but I don't want it to be put something to her which is not correctly stated.
What is that?
And that is what Colonel Otto effectively stated is that she's not a PCR analyst, that she's not proficient in that area, and that as far as the negative and positive controls, that she was going to refer this witness to somebody else should be asked about that.
What do you say about that, Ms. Galloway?
No, I'm difficult to understand. I was never going to cross-examine with this witness on case law. I was merely putting the thought to her that the court was of the view that certain safeguards built into the process is enough to guarantee the safe acceptance of it. I only wanted to comment on that. That is all. With regards to the PCR of the court, I was never going to cross-examine on that.
Yes, my lord, that's the whole point, though, is that the sentence which deals with this aspect in the case is clearly not that simple. It refers to a myriad of factors which the court took into account, such as the automation of that lab, for instance. So to put that in any way as even if it's put to her as having to comment thereon, is saying that there's a stamp of approval by a court on those facts, and that's not what happens here. So it would not be fair to have a comment on that when it's not clear that it's involved.
What did you say, Ms. Galloway?
No, I was in any event not intending to take that matter further.
Okay, Mr. Mathieu, she's not taking that matter any further, so can we leave that as it is there?
Yes. And then
The other matter about the case that is referring to, can we stand down cross-examination?
No, there is no further cross-examination in
that case,
and then, but then the remaining aspect was what was put to the witness as the second last question.
Let's see that. She's not pursuing that
No,
anymore.
she's not. Okay.
Okay. You're still on the oath, Doctor?
As it is.
You can sit, please. You can have a seat.
Thank you, my lord.
If you're comfortable. Ms. Galloway?
Thank you, Lord. Just the matter that's down from before lunch, your exhibit EEE10, the discovery timeline. Nora, I indicated before that we have not yet worked with it. I unfortunately cannot at that point in time already tell you that I agreed with being accepted as an exhibit. May remain a provision. I'm looking for feedback from Victoria on specific aspects of this document. I would however like to just clarify something with Dr. August regarding this document. Dr. August, do I understand your exhibit EEE10 correctly? The last paragraph 17, your summary. Am I correct that in that summary is the operative part of this document, in that you list there what you did not receive, what you're still waiting for? Is that correct?
My lord, that is correct. This document also pertains to a previous outstanding question that the court actually asked me, that I still need to address.
But I'm correct that you know 3 sub-headings, A, B, and C, 4 SOPs you have not received at all, and then 5 you received, but it was stated that it's not relevant for particular FSL, and 7 you indicated that it's not relevant, although you are of the view that because it's mentioned in other SOPs it is relevant.
That's correct, my lord.
So, in actual fact, there are 4 SOPs which you did not receive, and you also did not receive any explanation as to why it wasn't given.
My lord, the explanation, I will just have to verify, but the 4 that we did not receive, I will have to clarify the explanation, what that was.
I'm saying that I understand your summary. 4 you did not receive, and
Correct.
there was any explanation given to why you didn't get it.
My lord, and it's the last part of that question that I will have to verify in the document.
Okay. I just want to make sure that I understand you correctly so that I know what to ask from you. Okay.
My lord, if I may, there was a question outstanding from the previous session that the court had asked about in which cases previously we received SOPs and data and the paper trail of data generated. So I don't know when is the appropriate time to address that.
If counsel doesn't ask you that in cross-examination, and hopefully your own counsel will ask you that in re-examination.
My lord, the only reason I clarify it is, as I recollect, it was a question from the court.
Do you want the correction from there?
My recollection is that it was a question from
The court?
From the court, correct.
But you answered it really.
No, my lord. The discovery timeline that the state referred to
Oh, I see.
refers
Okay,
to this
can
particular.
she just clarify this, Ms. Galloway?
Look, maybe there is something more that I need to ask the witness in this regard, but can I do that until I've received the information from the laboratory before I make a statement to the witness which is not ready?
Okay.
So, my lord, apologize. If that is so, that's fine. If that answer that she wants to still present to the court,
She'll come in later.
at the same time, yes.
Dr. Walters, just another aspect with regards to the SOPs. As I understand your evidence, you are of the view that the SOPs are of critical importance to the extent that if the laboratory does not comply with the SOPs, their results are, as you put it scientifically, invalid.
My lord, that is correct. That I believe the same answer or similar question was put to me this morning. I quoted from the ISO guide how important the SOPs is. I will spare the court's time and not reiterate those points.
And you indeed then also, as you testified earlier, you use the SOPs to audit the scientific process followed by the laboratory.
Yes, my lord, I use the SOPs and also the ISO 17025 guide that the lab stated that it's a standard that they also follow.
So I just want to make sure, Dr. Walters, for you, it is very important that the laboratory follow the SOPs religiously.
My lord, yes, the SOPs are not guidelines, they must be followed.
Then why do you compel the laboratory to break their own SOPs or not follow their own SOPs, Dr.
My lord, with respect, that's a very, yes, my lord, sometimes my ankle needs some reprieve.
Oh, your ankle needs a reprieve. Okay.
So that's a very wide statement. I have no idea what the state specifically is referring to when the state says that I'm compelling the laboratory to break their own SOP. So could I please get clarification?
Let's see what he says.
SOP.
But please sit down, relax. You can take your time in answering the question.
As SOP FSL 0010F/1 is the confidentiality of information declaration. Attached to it is an email that I received when the SOPs were handed over to you. You refused on 2 occasions to sign the confidentiality clause document, which is part of the laboratory's SOPs, which you say is very necessary.
My Lord,
My Lord, if I may,
my Lord, no.
Legitimate objection.
This is legitimate. Obviously, this must be seen in the bigger mix of constitutional rights, etc. This was effectively, she was asked, the information was asked on behalf of the accused. We all knew that was the journal that was being used. So, I mean, how can it must they go ahead with the Constitution? It was
Ms.
found-
Galloway,
What was it? Oh, sorry.
you can remedy that in re-examination.
my Lord,
Please carry on the cross-examination.
my Lord, I'm unsure whether I'm now allowed to answer or not. Yes. Thank you, my Lord. This document was actually presented to me on more than 2 occasions. I think it may be actually 3 or 4 occasions. In the past, the laboratory had a different looking, so it also had a confidentiality agreement which looked different. This particular one, every time when we collected information, I asked whether the document had changed. I was told that it had not changed, so then I again refused to sign it. My reasons for not signing are, I could not sign it, my Lord. And I wish I I now wish to tell the court why I could not sign it. The document states, I will retain confidential any information received from the Forensic Science Laboratory. My Lord, this line does not pertain to information received in this case. It pertains to any information I receive from the FSL. So, within the forensic science sector, I receive a lot of information from the FSL, also via the press. I cannot be held accountable for that. So I learn about instances that's happening in the laboratory as the rest of the public. Then the next line says, I agree not to disclose any information about the FSL. That's a very wide statement. I simply cannot sign that I will not disclose any information about the laboratory. To its extreme, it can be information already in the public domain. Then it says, I commit to protect and safeguard information that I have acquired. So throughout all of the court cases that I've done over 18 years, I've treated the information until it is in the public domain as confidential. The next line says, I declare that I will keep the information gathered and reports in this regard confidential. My Lord, that's indeed what we do. However, as I understand the law, not being a legal scholar, once the documents are submitted to court, they become part of court record or public record, and anybody then has access to that. Then the next line says, I will not compromise/reveal this information and reports or make it available to any unauthorized third party. My Lord, again, this information, some of the information I received will become part of the public record, which I cannot vouch for, that I cannot then also, like any other citizen, have access to it. Then it says, I will not divulge the information or reports in this regard for my benefit. So, in the strongest sense, that means I could not be paid for the work that I do in a case, because I am benefiting from it monetarily. I will not reveal, the next line says, I will not reveal confidential information to other persons or organizations which may lead to loss, embarrassment, or damage of the organization. Now, I don't understand, I don't have insight into how the FSL would interpret loss, embarrassment or damage, but in a wide sense they could also interpret embarrassment, aspects that I bring out or mention in a case such as this. Then I cannot reproduce copies of the data received. I'm only allowed to make notes related to the case. I couldn't foresee how I could make copies for counsel, for instance, or for other people in my own organization if I can't make copies, if I can only take notes. Then the next line states, I accept that information gathered and related reports are confidential, and I herewith undertake not to make known anything in this regard. Again, the statement is very broad, my Lord, not something that I can put my signature to. Then it says, I know and I understand the contents of the above declaration. I have no objection to taking the prescribed oath, and I consider the prescribed oath to be binding upon my conscience. The first time and every subsequent time that this document was offered to me, the first time was after a meeting, if I recall correctly, in my own company's boardroom between myself, Dr. van der Merwe, and 2 members of the FSL. The only commissioner of oaths I had assumed to be in that room would be then members of the FSL. I felt uncomfortable at that point and subsequently asked my own contracts lawyer, who referred me to, my Lord, and I'm not the legal scholar, regulations governing the administrating of an oath or an affirmation, and it's Act 16 of 1963, Justices of the Peace and Commissioners of Oaths Act. And on page 4 of 4, under legal implication, it says, if an oath or an affirmation is not taken correctly as prescribed, and the matter goes to court, the affidavit will be declared valid and may have serious consequences, which, for example, in criminal cases may lead to the acquittal of the accused. I don't know if this is applicable to this case in a legal sense. Whatever stood out to me and made me realize that I took the right decision in not signing the document is that it is an offence on point 3 to make a false statement, knowing it to be a false statement in an affidavit. So since I couldn't guarantee the confidentiality of information after it's submitted to court, I felt that I could not guarantee, so I would have signed it knowing that to be a false statement. And then point 5, a commissioner of oaths who attests affidavits is required to be impartial, unbiased and entirely independent of office, and I would presume there's a "the" missing, of office when affidavit was drawn up. So my Lord, this document was also, this same issue was raised in a case last year where I actually took the opportunity to consult with the senior advocate from the NPA who was involved in the case. And I'd asked if this statement was just drawn up more narrow, referring to the specific case, pointing out no, in the previous case. Whether that would not be more appropriate, because as it is, I feel that I cannot sign this form. That state prosecutor, and I neglected to look up his last name, then also spoke to the members of the FSL and also told them that he would not have expected me to sign this declaration because it is too wide. So my Lord, it's not because I want to break confidentiality before documents go to court. It's not because I want to do anything else with it, but I felt uncomfortable signing it, and I did not sign it for these reasons.
Dr. August, firstly, you presume that the members present at that meeting were officers who were capable to attest to the statement. You didn't go through the process to verify that.
Lord, sorry, I have to object again. This is such a collateral issue. She was a postbox in that regard. If we wanted to, we could have said to the FSL, send the documents to us. It was a matter of convenience that it went to this witness, because it's just a direct pipeline.
Mr. Matthias, this deals directly with the issue what's at issue here. It's perfectly legitimate cross-examination. It's not a collateral matter. It's got to do with her expertise, her willingness to subscribe to the confidentiality. Please, if you object on relevant ground. This objection is not well taken. She's entitled to cross-examine on this. Ms. Galway, please carry on.
Dr. Walters, from what you testified now and the act that you referred to, you didn't actually go through the process of attesting to any affidavit or to that document, did you?
My Lord, no, I did not attest to this document. I did not sign this document.
So you cannot.
My Lord,
assume
if I may
access-
complete.
Answer? Carry on.
So, the only 4 people who were present in the boardroom was the 2 members from the FSL. Neither my colleague nor myself are a commissioner of oaths. As far as I understood it, I needed to sign it in the presence of the commissioner of oaths. Because other
Of a
documents-
commissioner of oaths.
a commissioner of oaths. So at that point, this was after the meeting was conducted, we already had the information in our possession. The form was pushed across the boardroom to me and says, now you please have to sign this. I said, I need time to read through it. I read through it, I realized I could not sign it because it was too wide. And every time since then, when I was asked to sign it, I specifically asked whether the form has changed, given the case in Bloemfontein where these 2 members of the FSL were also present. I was told every time that the form has not changed, and for that reason, every time I said I could not sign it. My Lord, it is...
The commissioner of oaths, you could have taken the form and gone to any other commissioner of oaths if you wanted to.
My Lord, that may be so, but in the boardroom, when I was asked to sign this form, that was what transpired.
I get your point, there was no commissioner of oaths there, but nothing prevented you from going out and getting a commissioner.
And also when I went to the forensic science laboratory, my Lord, it was only the 1 member of the FSL who continued to hand us the documents.
Did you assume that that member is not capable, not a commissioner of oath, or did you make inquiry?
I did not make inquiry, my Lord.
Why did you convey your reservations about this document to any of the members from the FSL?
Yes, my Lord. In the court case which I mentioned in Bloemfontein, there were, and I hope I get the titles correctly, but I believe it's Captain De Wet or Lieutenant Colonel De Wet, or he was present, and I again do not know her exact title, but Colonel Bianca Boetes was present, and then there was a 3rd member of the FSL present, and I don't know her title, but I presume, I know she arrived later in the case, so I don't know if she was present when we discussed this particular issue, but her last name is Mortimer, so she was also there. There were definitely members of the FSL present when I discussed this issue with the state prosecutor in that case, and I explained that it is too wide and what my concerns were.
Why did you not simply draft your own?
My Lord, from my side, the way that we treat information is we deal with it in a highly confidential manner. It is, we don't, so I did not draw it up. I did not think that it was necessary to have this in place from my side, because I did not require it. I already prescribed to specific ethics guidelines in my company, which prevents me from disclosing confidential
Okay,
information.
that's your side. If the other side wanted a confidentiality agreement,
My Lord, I
you
would,
just draft on your own and say, okay, here's what I'm prepared. Or the one you had, delete the sections that you found unacceptable and sign the kind of confidentiality agreement.
my Lord, that is something I can do in the future. I can draft for the FSL.
Or delete the sections that you don't want on the form itself. And then, in other words, scratch it out. And say the rest I declare, accept the confidentiality agreement. But presently stated, you have not signed the confidentiality agreement.
I have not signed a confidentiality agreement, my Lord.
See, Dr. August, the reason I put this to you is that the fact that you refuse to sign this document based on your objections to this, it creates the impression that you are willing to interpret the SOPs, which are applicable as far as it concerns you, but then you turn around and say, you say, no, the body they must comply with all the SOPs. That is the reason why I asked you this.
My Lord, I cannot sign a document which I know to be a false statement. I today hear what my Lordship is saying is perhaps drafting one from my side is a good idea, and trust me, that will be acted upon, because that may solve it, and then the legal department of the FSL can then approve it, and then that is a document that we can use in the future, or I can go through the document and then cross out what I do not agree with and then sign it. But as the document was presented to me, my Lord, I could not, in good conscience, sign it knowing that I will be making a false statement.
The false statement part you refer to is because the papers will be used for court purposes.
The papers will become part of, as I understand it, public record.
And the FSL in handing you these papers know fully well that you require them for court purposes.
Yes, my Lord, that is true. My Lord, the reverse of that argument also holds that if the FSL knows that these papers are required for court, then actually what they are talking about, I now realize only now realize, but what I realize is that they are concerned about from the time that I receive it up till the date of court, because eventually it will be court record and in the public domain.
Dr. August, I note from you, it's an article that I found on the internet, and you also allude to that in your CV, in Forensic Science International magazine. This one is dated 2013, and you were listed as a corresponding author, that you market the services of DNA Biotech in that you provide trainings in the legal profession with regards to DNA evidence. Part of that training, you specifically note an article about, or a training about evidential value of DNA evidence. Am I correct?
My Lord, yes, we provide a training course called Essential DNA Evidence, and we attempt to help the legal profession and other scientists who want to know how to deal with DNA evidence in court. I don't have the index in front of me, but yes, a part of it does deal with evidential value.
And evidential value with regards to DNA evidence is indeed extremely important. Do you agree or not?
My Lord, as in everything, context is key. So yes, the evidential value is important.
So in cross-examination, an issue was made with Lieutenant Colonel Otto about the way that they decide which samples to submit for analysis and which not. In the sense that she said that we also apply principles of evidential value to decide which samples to analyze and which not. An issue was made about that this is a critical decision and you decide randomly which samples to analyze. If you are, as a DNA expert, confirm the principle that the context or the evidential value of DNA is very important. Why isn't she taken to task about using that as a decision or a criteria to make a decision?
My Lord, I want to request that the question just be repeated.
See, Dr. Olkers, you confirm that the evidential value of DNA evidence is very important. When Colonel Otto testified and said that the laboratory, when they decide which samples to analyze and which not, one of the criteria that they use is the evidential value of the samples they were given, or the evidence they were given, exhibits. She was taken to task about the fact that they make this critical sample this early in the whole process. And it's a final decision, if I remember correctly.
My Lord, I want to understand the question because it seems as if I'm being asked why counsel asked a specific question. I've already testified that evidential value is indeed important.
Maybe I can rephrase the question for the witness. Dr. Olkers, you agree that evidential value of DNA is important?
Yes, my Lord.
You earlier testified that you sat next to counsel and you gave him notes, you verbally gave him questions to ask. We need to Colonel Otto to task about the evidential value of samples.
My Lord, I have to object. It has to be placed in context of the question that I was taking to task Colonel Otto about a decision about the blood status on the pants, and that the choice of that in the context was important, an important choice to make. That was the context of that. Evidential value, in the broadest of terms, of course, the world knows that the DNA has evidential value and that evidential value is important. The context of this was a choice of using certain samples or not. That is the context of the question. You cannot be given such a massively broad statement such as you say evidential value of DNA. There's no one in this room who doesn't know that. So it has to be placed in context.
Mr. Mathieu,
it's not fair.
Ms. Mathieu, Ms. Galloway is presently cross-examining his witness. The question put is a patently fair question. Ms. Galloway, will you please carry on?
See, I will maybe whittle the question down even further, Dr. Olkers. If you as the defense's DNA expert agrees that evidential value is important, why did you not make counsel aware of that? That listen, sometimes the laboratory make choices about the example. I agree, evidential value plays a role.
My Lord, during preparation for the case, I did make the point that evidential value is important. What the state is asking me is why I didn't, I can't say interrupt because I can't interrupt counsel, but didn't make counsel aware. As my Lordship is aware, there were several times when I tried to pass a note. I don't make the strategy in the case, so I can't pose the question. I can only advise counsel on what is pertinent to the DNA evidence.
Just to confirm the importance of the evidential value of contextualization of DNA evidence, I previously, when I asked you questions about this in the court remark about it, I said I will come back to the Mutina judgment where your evidence was accepted with regards to your criticism against the DNA analysis. The court eventually found that it couldn't rely on the DNA evidence. But if one goes to look at the facts of that matter, it was two accused charged with the murder and rape of the victim. Accused one admitted to having stabbed the deceased. He gave a defense of self-defense. The second accused had alibi defense. The knife used in the incident had blood on it, and so did the pants of accused number 2. The DNA on the pants of accused number 2 was the only evidence linking accused 2 to the commission of the crime. Now here is where the DNA comes into play. The only thing is, the 2 accused and the deceased shared 5 of the 6 identifying alleles that was used at that time. That time they used 6, now they use 9 plus the gender marker. And the technique used was also different. They used the HLA-PM technique, where now it's the STR technique, much more sensitive technique. You agree?
Yes, my lord, the STR technique is much more polymorphic, so the HLA marker technique was not as polymorphic, so the locus didn't have as many alleles. So the STR test, I think everybody agrees, is better.
And based on that, it was found that it is too difficult to distinguish the two, or to exclude both of the 2 accused from the DNA on accused 2 pants. Is that how you remember the facts, Dr. Walters?
My lord, it's been a while since I've read through the McKenna case. As I remember the facts, the issue at hand were more than one. It was the quality system that was not followed, so the SOPs, there was an issue of duplicates that were not performed, if I remember correctly. And I don't have all the issues at hand, but I can obviously, if the state has the judgment in front of her, as I do, then she can point me to the line and I can confirm.
Just also to take it further, Dr. Walters, in that case, the chief scientific witness of the state was recalled by the court and he conceded your criticisms against the process. You remember that?
Yes, my lord, that happened, and it was a female, it was, and I don't know what the title is, but the last name is Breda.
So, the matter at hand, the one that the court is dealing now and testifying now, and the fact completely different from the McKenna matter.
My lord, yes, because the HLA marker system is very different than the STR system.
That is the science, the applicable science, which is also changed in the meantime.
Correct.
And then the state witness conceded your criticisms were correct, which didn't happen in this matter.
That's correct, I would presume, my lord, because I have not spoken to Lieutenant Colonel Otto since she's seen my report, but during her cross-examination, that was clear.
Now, similar to what is similar to the McKenna matter, you would have some months to verify the process followed by the laboratory against the SOPs that you did receive.
Yes, my lord, I have had time to.
And your knowledge from previous dealings with the laboratory and the processes they follow, you could even use that to maybe supplement what they've given you now.
My lord, in each case, the reason why we request the specific SOPs, because these SOPs change over time, the lab brings out new revisions, so we cannot use, for instance, knowledge that I have of a SOP of 2005 on this case, because the SOP in this case would be vastly different. Technologies have moved on since the McKenna case, for instance, since the Parker case, even though the same STR technology was used. So we request the pertinent SOPs in each case and then measure and then compare that to the data that we receive.
Now, the time that you had available and the information that was made available to Dr. Walters, There are certain aspects that I would like to confirm as I understand your evidence in chief. Starting with something that we've already commented on this morning, and I'm not sure that I understand your comment correctly. I'm referring you to Exhibit AAA1 that was handed in during cross-examination of Colonel Otto. I understood this.
You have to take it out, please.
No?
You have to take it out.
No. I just want to know what exactly the witness intended with this document. This was, as I understood, this was handed in. And my recollection, my notes are that this is an example of a paper trail of a sample that was done correctly. This morning you said...
I'm sorry, I was just saying correctly, it was said in the cross-examination, it was not contested. That's all. It's not contested.
It's better?
Dr. August, can you maybe answer the question whether it was done correctly or whether it was not contested in your audit of the processes?
My Lord, if I have to answer that, I will have to refer to a summary document that I made in this regard for all the samples. As my Lordship can appreciate, there's 151. The reason why these pages were specifically selected was just when I intended to make a handout, as I eventually did, of the triple E1 is the exhibit number, and I wanted to verify with counsel that all the papers, all the forms that are generated are exactly generated by each of these processes. For no other reason, in my mind, this sample was selected. Now, if counsel then chose not to contest the sample, that I cannot speak to, but I can verify tonight in my own summary whether there were indeed a problem or not, or an aspect that I questioned with the sample. And I could get back to the court on that tomorrow morning.
I was just trying to establish exactly that from you, Dr. August, what the reason was for this exhibit to be handed in. Is this an exhibit that you considered the sample not to be correctly processed? Or what was the reason for handing up that exhibit? So if you can please verify that.
My Lord, as I just testified, it was to verify that we understood each and every document that is generated after every process. The laboratory has, as I testified this morning, has or has, and I'm not sure which, an automated system in place, a semi-automated system in place, and a manual system in place. So when we do court cases, often it would be a case that is processed in the Pretoria system and in the Pretoria FSL, and we will be told that it's a semi-automated process. So that is then different from the manual process, which we were told in this case. And so to verify that we do not make a mistake or later on refer to a wrong copy within the paper trail of a specific document, of a specific sample, or evidence that was submitted, that is the reason that counsel verified with Lieutenant Colonel Otto whether this is indeed the sequence in which these documents were, or the processes which generated these documents.
Then, just to confirm again, you testified this earlier, you testified that the samples, or sorry, the paper trail that you requested...
My Lord, I sincerely apologize. Can I just have time to make a note? I don't want to forget to get back to my Lordship tomorrow morning. Thank you, my Lord.
Now, if clear?
Yes, thank you. I will.
With regard to your exhibit E1, it is the DNA analysis process where you read the flow diagram. I'm still not quite sure what your answer in this regard is. If you asked the samples, the paper trail for the samples that was reported on by Colonel Otto. Is that correct?
My Lord, if I apologize. Can the question just be repeated, because I think there's a link between the AAA1 and EE1 that is not clear to me from what the state has asked.
I've moved on from AAA1.
Thank you.
I'm trying to establish from you now something else. As far as I understand your evidence, you asked for the samples, the paper trail of the samples, as reported on by Colonel Otto in the 4 reports that you received.
That is correct, my Lord.
You did not specifically ask any paper trail for samples that, although submitted for analysis, either did not contain DNA or was negative samples. In other words, they weren't reported on.
My Lord, I already answered this question this morning. I will do so again to make it clear that the samples that the FSL wished the court to take note of were the 151 samples that were reported eventually in the 4 affidavits of Lieutenant Colonel Otto. I was tasked to verify that those samples were scientifically valid. I had assumed that within the FSL, samples sometimes are of just such a nature that you cannot, for instance, get enough DNA, or that the presumptive test is for instance, negative, then those samples will not flow through the process, if I understand the SOPs correctly. So the reason why the 150 samples were requested and not the 216, which I now know is 216, I did not at the time, it is just because the samples that the FSL wanted the court to take note of was 151, and that is what we requested the data on.
So then, the answer from the other side, you did not request any paper trail from the samples that didn't flow through the complete system.
Correct, my Lord.
When Colonel Otto was cross-examined, the issue of swab 63 came up. That is the blood droplet on the inside of the laundry door. That is the door connecting the kitchen to the laundry in number 12 Cosco Street. You were given a paper trail or documentation with regards to swab 63 during the cross-examination of Colonel Otto. Is that correct?
My Lord, if the state would just refer me to the exhibit number.
It was not handed in Dr. Walker. When Colonel Otto testified, it was said that you did not receive that paper trail. She brought the paper trail with, and it was handed to you.
My Lord, there was I recall that there was a sample that was a reference sample, not done in duplicate if I recall correctly, but I will have to verify in my own notes. Lieutenant Colonel Otto then said that it was done in duplicate, and she, I believe, handed those in. I will just have to verify in my own record.
I can help you further, Dr. Walker. This is the sample that was not analyzed because the sample didn't contain any DNA. Colonel Otto's evidence was that it's possibly because it's animal blood, and the labs kit or process does not pick up animal DNA. Maybe that would help you to find the reference. The only thing that I wanted to ask you on this is whether you had an opportunity to go through that paper and whether you confirm the processes are correct. But it appears that it wasn't given to you.
My Lord, I cannot categorically say it wasn't given to me. I accept the state's word that it was given to me if that is what the state is saying. I will just have to find it on my side and verify what the state needs for me to verify on that sample.
Now, what I am sure what the criticism was, and this is now taken from the cross-examination of Colonel Otto, for lack of a better term, the faults that you came up with after having audited the process of the laboratory. And I'm working through the exhibits handed in during cross-examination of Colonel Otto. The first one was AAA 2, read with AAA 3. It is the 1979 certificate of the Lieutenant Colonel Otto, which was not signed in terms of ISO 17125. When it was pointed out to you by Colonel Otto that the ISO is only dated 2005 and she cannot go back, date the certificate, go back to sign the certificate. I infer from the fact that you no longer testified on this aspect in chief that you agree with the evidence in this regard.
My Lord, if I recall correctly, the certificate was issued. It doesn't carry a date. And I think that was the issue because 888 that I have in my hand is indeed signed by the head of biology, Pierre Hubert, and the training manager, Mrs. Popst. So I think it was the issue of the date.
Correct.
And I cannot recall what date this was done, but I do recall that the ISO guide states that it must be dated, and if the certificate was issued prior to the ISO guide being in place, then I accept that they could not go back and date it, although it would have been a mere administrative process to indicate the date and attach the proof of the date to it. But I accept that this certificate is not dated.
Then moving on, the second fault or non-compliance with the SOPs that you pointed out is exhibits 888 and 5 that were handed in, which relates to the proficiency test. Test 14-586.
Yes, my Lord, that's indeed 888-4, and then the certificate of Lieutenant Colonel Otto 888-5.
During cross-examination, please correct me if I'm wrong in this regard, it was put to Colonel Otto that this is indeed the proficiency test.
My Lord, this is the proficiency test that was offered for the proficiency of Lieutenant Colonel Otto in the documentation that we received.
So I'm correct then to understand that it was put to her that she isn't proficient based on this doc, specifically exhibit 888-4.
That is correct, my Lord.
Earlier today, you testified, you made calculations about now there are 12 analysts who are not proficient in reference to this, am I correct, in reference to this text?
My Lord, I was asked by the court, and if I may just page through my own notes, I was asked by the court yesterday to verify how many other analysts are there not proficient that worked in this case. And there is indeed 12, and 6 of them are related to this particular proficiency test. I do have a list of names, I just don't have it printed out for the court.
See, the fact that it's not just Lieutenant Colonel Otto who is not proficient was never raised with her or in any way during the state's case. It's only now when you can testify in answer to something that the court remarked on, that it was now all of a sudden not just Lieutenant Colonel Otto who's not proficient, but indeed 12 analysts of the laboratory.
My Lord, with great respect, I could not have foreseen what the court would have asked me.
That's why you indicated earlier, 12 of the analysts are not proficient.
After the court asked me yesterday to go and verify, so
You explain now why you didn't indicate earlier that 12 analysts were proficient.
my Lord, it was indicated to counsel. Why counsel did not pose the question, I cannot tell. I don't make the strategy. With great respect to counsel, I had to already say that yesterday. The proficiency...
So you did indicate to your counsel that they didn't raise. That's your answer, short answer.
My Lord, I took great pains yesterday to describe how the scope of the mandate narrowed. So, yes, I did indicate to counsel, because it was in the report that I generated when after the audit was done of all of the samples.
Leaving aside the other 6 analysts that you say are not proficient, the 6, is that including Colonel Otto?
That's including Colonel Otto.
With regards to this specific test, as reflected in Exhibit AAA4, Dr. Walters, you base your opinion on this, if I understand it correctly, merely because of the answer of no that is given under item 3 on the DNA interpretations.
My Lord, that is correct.
Other than the results here and the certificate which you copied and handed in under Exhibit AAA5, do you have any other information as to how this test was indeed presented to the laboratory or the 6 analysts, including Colonel Otto, when the proficiency test was done?
My Lord, proficiency tests are done the same as any other sample, as Lieutenant Colonel Otto, as is my recollection of her testimony. She also reiterated during her testimony that the CTS proficiency test system requires of them to follow their own SOPs, which they did, then generated the incorrect answer, and they have now actually updated their SOPs, was her testimony, so that it is in line, because she referred to this and said they are on par, or didn't refer to this, she referred to some document and said this, they are on par with the rest of the world. Now, if you are on par with the rest of the world, you cannot be one of the three out of the 132 laboratories that got that answer wrong. Then it means that you are one of the outliers. They have now realized that, they have rectified that, according to Lieutenant Colonel Otto's testimony, and their CTS reports will now be reported correctly, because the question that was posed specifically referred to the following, and I quote, based on the results obtained from the DNA analysis, could the victim, which they knew to be a female victim, and the suspect, item 2, which they knew to be a male donor, be a contributor to the question stains. So if you are asked about whether both a female and a male DNA profile can be read into a mixture, one cannot use a system that will only allow you to report on the male component, because then you should not have used this particular proficiency test or made it very clear, as some other labs who also completed this proficiency test. And my Lord, I hesitate to refer to the entire test. It's available on the internet. I believe it's something like 100 and something pages long, which I will not hand in. But during that test, some of the laboratories actually did not provide an answer. They did it merely for database purposes, and some of them said, and I quote from one of the answers, they said, no interpretation reported, data analyzed for database purposes only. And there is one laboratory who, there were three laboratories actually, who provided no answer for item 3 because they knew that they could not provide the correct answer using, I would presume, the same type of SOP or same type of system where only the male component is measured. For me, the important thing in this CTS report, my Lord, despite what it means in this case, is that the FSL have now realized that the SOP is not aligned with the rest of the world in terms of this particular aspect, have rectified the SOP, and will now be able to provide the correct answer if the samples are processed correctly. So that is just looking into the future.
Dr. August, I still haven't got the answer to the question that I asked you. I asked you, do you know in what manner or how this test was given to the internal, in what manner they provided? The laboratory made her go through the test.
My Lord,
Do we have information on that?
My Lord, I did answer it. I said the proficiency tests are analyzed according to the SOPs of the laboratory, the same as any other sample. That is also, to my recollection, what Lieutenant Colonel Otto testified.
There's a slight difference between my question and your answer, Dr. August, but I will leave it for argument later. Do you agree from your answer referring to other laboratories that the laboratory did get a result, a DNA result, when the samples were analyzed?
Yes, my Lord, the FSL, and when I say FSL in this regard, of course I mean FSL Western Cape, did report an answer.
So they followed the procedure, and then the interpretation of the DNA results that they obtained is given under item 3, and that you don't agree with. Is that correct?
Yes, I do not agree with their answer under item 3. That is, the answer is incorrect.
So the evidential value that Colonel Otto testified about, that she said it's more important to see whether the male DNA is present, it being a rape case, than the female DNA. You don't take that into account.
My Lord, I do take that into account. There are cases where several female victims are raped. So one would have to then look at the DNA profiles of also the victim. I realize that a lot of the cases that we see, the FSL does not report the profile of the victim. But if there is a mixture, one would have to exclude the DNA profile of the victim.
I don't know why you refer to more than one victim that was raped, Dr. August. In this example, it is clearly categorically stated one female donor, one male donor.
Yes, my Lord, that is what I testified. I then went on and used an example of why it would be prudent to also, and scientifically correct, to also report on the female victim's profile.
So you do not agree with Lieutenant Colonel Walker that the mere fact that the laboratory got a result, the DNA result, is enough to declare them proficient?
My Lord, I categorically do not agree with Lieutenant Colonel Otto in this regard, and may I please explain why? Getting a result, and I'm trying to think about an analogy, and the analogy that comes to mind is one that either I think I have used before. When we look at blood alcohol levels, if the blood is drawn too long after the fact, or if the blood is not stored or handled properly, a result will still be generated, but that result will be wrong because it may now lie in a different category or in a different range than what it's supposed to lie. Can I also state the following analogy that comes to mind? That when you look at the end result, for instance, I'm driving over a red light, and it's late at night, there's no other cars in sight that I can see. I drive over the red light, I don't hit a pedestrian, I don't hit another car, I arrive safely on the other side. The fact that I arrive safely on the other side doesn't mean that I haven't broken the law. So the analogies are vastly different than working with DNA samples, but I trust that the gist of the analogy comes through, and that one cannot only look at the end result and say that every step preceding it is therefore scientifically valid and in order.
Dr. Walker, this is the second time you mentioned the blood alcohol analysis. Just like in that regard, blood alcohol analysis is in no way applicable to DNA analysis, except for the fact that they're both scientific processes to get some sort of data or information to make a determination on something. They are not in any way similar. The difference in the two processes lie in the purpose of applying the scientific process. With blood alcohol analysis, we want to know the exact amount of blood of alcohol in the suspect's blood at the moment in time when he drove that vehicle. So there are precautions built into the system to make sure that we get as close or stay as close as possible to that moment of blood alcohol. That's why there must be a certain amount of sodium chloride in the tube. That's why it must be kept preferably at a certain temperature. That's why it must be analyzed preferably within a certain period of time. You're nodding there, you agree?
My Lord, I've used it as an analogy. I've already said it is a different analysis, but similar.
Different, very different analysis.
Similar to the scientific process that should be used in blood alcohol testing, the scientific process should have been used or should be used in DNA analysis processing. One cannot simply look at the end result and because you get an answer, say, therefore every preceding step was done correctly. My Lord, I cannot make it more clear than that.
So, just for sake of completeness, Dr. August, the fact that the DNA is a totally different process in the sense, or the purpose is totally different in the sense that we want to know if at all, whose DNA profile can be read into a certain sample that was into evidence, that was handed into evidence. And all the precautions taken in DNA is to safeguard the process against contamination. The only thing, for instance, that a delay in time can cause to DNA sample is that the sample can become degraded. It can't add more DNA. It can't add the profile of somebody else. Because with blood alcohol, you can have subsequent fermentation. So the sample can, in principle, be altered by certain events. Whilst with DNA, all that can happen is the sample becomes degraded. You cannot analyze it either because DNA or for whatever reason. Correct?
My Lord, I've testified before, and I will say this again. You have to, if you want to make a valid conclusion, your interpretation has to be valid, your data has to be valid. And for that to be valid, the scientific process has to be followed. And how it works in science is the same regardless of which field of science you practice. The step-for-step analysis may differ, but the scientific process is the same, which says you start at a certain point, you have to follow your process, and then arrive eventually at your end result. You then interpret that, you analyze it, you interpret it, and you make a conclusion.
But then you go back and you also say, Dr. Olkers, you also say that yes, the laboratory did achieve or obtain results from the DNA analysis. It is the answer, the interpretation of that DNA analysis that you don't agree with.
My Lord, and therefore, the process, the answer is wrong because it was incorrectly interpreted. So the conclusion was wrong. The data may have been valid. The interpretation was perhaps incorrect. So the conclusion was incorrect. Therefore, the answer is incorrect. So to arrive ultimately at a valid scientific conclusion, all the preceding steps needs to be scientifically valid.
So you say, based on this one interpretation that differs from your interpretation, that all the analysts who work with this test or this sample in the test, all of them are not proficient.
My Lord, that is indeed the case. That is how proficiency tests work. You either pass it as a group or you fail it as a group.
You fail them as a group.
Fail them as a group, my Lord, because the incorrect answer was provided.
For what it's worth, Dr. August, as a prosecutor, I am not very much interested in where my rape victim's blood is found, unless it's found on the accused. If there's a mixture of samples with a male DNA who's a suspect in the matter, I would rather like to know about the male DNA than the female DNA. I know who my victim is.
My Lord, I cannot answer the hypothetical of the state prosecutor.
Now, if we move on to Exhibit AAA6, Dr. August. This was also handed in during cross-examination of criminal officers. The issue here was that the alphanumerical signature of the submission officer, if I have the term correctly, does not appear on this document in either of these pages.
My Lord, this issue was belabored in court. If I recall correctly, the outcome was it depends on whether you use it as a noun or not. Initially, we had understood that the 5KS is an alphanumeric number, and then we were told that the KS is in fact the initial.
So you accept that there is an alphanumerical signature on those documents?
There is an alphanumeric number indeed, my Lord. It says 5KS. And on
That
the
alphanumeric number is a signature. Somebody testified to that.
My Lord, there's not a signature that I see. I do see the 5KS, and if I'm missing it, I would ask. I see a 5KS, a 14KS. My Lord, there's a looks like an envelope, smear of body fluid, where the exhibit is called AB4, and then there's the laboratory number and the donor. I am on page 46, my Lord, of the data bundle exhibit AAA6. So this card contains an examiner initial, and I cannot make out what that is. But it could be, but I do see the 5KS, and I do see the 14KS, and I do see, so on all of these pages, I do see the alphanumeric number, and we were then, Lieutenant Colonel also pointed out that there is the KS of the alphanumeric number, I would presume is the signature or the initial.
So for purpose of this case, you accept that your interpretation of what an alphanumerical number is or should be is not the same as what the laboratory uses as an alphanumeric number. They interpret it differently.
My Lord, I think the confusion came in where the SOP spoke about an initial and an alphanumeric number, and I cannot recall the page number of that particular SOP. And that is where the issue came in, that I could see the alphanumeric number but not the initial.
Do you accept now that the 5KS, 14KS, 24, 23, 25KS is indeed the alphanumeric number?
It is the alphanumeric number, my Lord, as far as I understand it.
Then on that, in that same exhibit, Dr. Walker's page 2, with regards to the absence of the seal in the middle of the box, it is the photocopy on the top of page 2 of exhibit 886.
My Lord.
Neither Sergeant Hitchcock, Captain Hubert, nor Warrant Officer Nell testified with regards to this sample could remember whether or not the sides of the box were also sealed. Have you any evidence to the contrary that it was indeed not sealed?
My Lord, I was asked to look at the DNA profiles in this case, where we came across, for instance, something that is very easy to observe, where the exhibit 117, there was an 8 over it. That was easy. For me to look at this, I will have to look at what the council, I'm sure, can provide me with all the evidence of this. But do I have it in my possession? No, I do not have it in my possession.
See, Sergeant Hitchcock, Captain Hubert, and Warrant Officer Nell also testified that all of the samples collected on the scene were sealed in evidence bags that accompanies the sample boxes. Even if this one sample was not sealed, let's, for sake of argument, accept none of the 3 seals were attached to it. The second box was still sealed, and both boxes were sealed in the evidence bag. And that is why Warrant Officer Nell testified, I received all my samples in a sealed condition. Do you have any evidence to the contrary, i.e. that she did not receive the evidence in a sealed condition?
My Lord, I want to just repeat what I said before. I have literally no idea what Captain Hubert and I don't know what his title is, Hitchcock, Captain Hitchcock, I will call him for lack of a better word, and Warrant Officer Nell, what they testified.
I put to you what they testified in this regard, Dr. Walker. I'm asking you if you have any evidence to the contrary.
My Lord, no, I don't have in my possession evidence to the contrary, because I was not asked to look at exactly these either testimonies or conducts during the case of Hubert, Hitchcock, and Nell.
Lord, I understand that we sit a bit later, maybe today, but we started earlier. I'm moving on to something that is going to take a fair bit longer. In fairness to the witness, Lord, my next point covers almost 4 pages of my type of question. So, it's a
Okay. Shall we start tomorrow morning at 9:30 again? This suits everybody? For the rest of this week, we'll start at 9:30 to cover up the lost time. Mr. Van der Vaal, your bail is extended. Case is adjourned until 9:30 tomorrow morning.